Welcome to the Fixer Podcast.
Hello and welcome to The Fixer with experienced attorney and author John Tatoian. Thanks for joining us today. I am your host, Kevin Rosenquist, and today we are going to talk about navigating debt, disputes, and business law. John, great to see you. Thanks so much for being here.
Thank you. Good to be here.
Tell us a little bit about yourself and how you got into law.
My family had started the practice of law back in the 50s. My father started a law firm. So we've been practicing law for 1950, what's that, 70 years. So
That's a good amount of time.
Yeah, it's a good amount of time. But all my brothers and my father, except one brother, was all lawyers, and I just decided to eventually follow in those footsteps.
You said eventually. What was the delay?
The delay was probably stubbornness. I actually started a company, got out of college, started a company that did film and video production, and worked with Hollywood, bought up screenplays, option screenplays, etc. Like the mid 80s, late 80s. And I realized that I wanted more control over my life. And I remember very distinctly sitting in my family's law office and looking up at trying to figure out what to do with my life. And I just remember turning over and looking at all the books on the wall, and a light bulb went off in my head. And I said, in those books is information. And information, I quickly learned, is power, and probably the most valuable commodity that we have. So information is power, and the way you gain information is through knowledge. And that's when I decided to go to law school, to gather that information and knowledge and power, and have an opportunity to control my own destiny versus being controlled by other people. So that was really the turning point of why I decided to go to law school.
Wow, it's quite an introspective moment for you.
Yeah, so it was kind of one of those light bulb moments.
Yeah. So you wrote a book, Paper into Cash, and it focuses on turning unpaid judgments into cash. Can you share the inspiration behind writing it and what strategies from the book can help listeners facing unpaid debts?
Remember walking into my constitutional law class back in 1993, 1994, and it was before class. And I remember these two guys, they were just shooting the breeze, and they were talking about how this landlord he needed money right away. He couldn't wait for the tenants' money to come in. And he said, I'll pay this landlord money right now, and then the tenants will owe me 100% of what they owed him. And the spread, the difference will be the profit. So that was the inspiration for starting up when I got out of law school, my first company, which was ACR Systems, which that's exactly what it did. It purchased up what they commonly called junk debt or bad debt that hasn't been paid, that's defaulted on. So that was the inspiration for ACR Systems, is buying up this junk debt at a very, very steep discount and collecting obviously more than you paid for it. So that was the inspiration for it. Again, that developed into ACR Systems, which I didn't have a lot of money back then. I think I had I remember looking back when I got out 1997, I think I had $1,500. So I developed a technique where you would kind of people buy houses with no money down. So I developed a technique to buy this junk debt or bad debt with no money down. So I wouldn't have to, but I would give more to the original owners of the bad debt. So eventually I branched off ACR Systems because it started to make a good amount of money. And the companies over the past 26, 27 years, I capitalized a whole bunch of different entities. I mean, there's the top of my head, ACR Systems, ACR Enterprises, GTH Enterprises, the KLX Acquisition Trust, the Worldwide Asset Group, Tinian Trust Holdings, JPT Holdings, John Tatoian Enterprises, Tatoian Capital, John Tatoian Law, Tatoian Associates, Tatoian Global Media, Freeport Trust Holdings, Silver Screen Entertainment. And they've all all those conglomeration of entities, as we sit here now, have kind of morphed into essentially John Tatoian Enterprises, which owns JPT Holdings, which invests in public companies, Tatoian and Associates, which finances businesses, Tatoian Global Media, which finances entertainment projects, John Tatoian Law, which is why we're here, a legal arm, and there was the Worldwide Asset Group, which still buys debt, but still buys junk debt, but has enough money, has millions of dollars now to buy it, pay up front instead of using no money down technique.
Okay. As a solo attorney, you emphasize personal attention in your practice. How does your one-on-one approach with clients benefit them compared to maybe working with larger firms?
I think there's very little emphasis in personal attention and understanding of someone's problem, a client's or potential client's problem with a large firm. A large firm is their goal and their focus, and I can say this from personal experience, is getting your money. They do this in a number of different ways. One of the most complained about ways is they bill in increments. They bill in, a lot of them bill in like 6-minute increments, and they bill for like walking across the room and filing something or reading an email, or just, they'll bill for everything. I mean, they bill for taking off their shoes while they're reading something. So you don't get that personal attention, and you don't get that understanding. Sometimes they pad the bill, which is highly unethical, illegal. So it's also very difficult to reach people, the lawyer that's assigned to you. And it's extremely difficult when you're calling up the firm to locate the lawyer that you want to commute. They'll transfer you all over the place, and you just go around in circles. And the other thing I found with the administrators, like the partners, the people at the higher levels of the law firms, are less than pleasant. I'm trying to be very, very tactful.
That's a very nice way to say that, John. I'm impressed.
Less than pleasant and bordering on belligerent. This is not anecdotal information in 27 years of experience. If you're a client that's a huge conglomerate with hundreds of millions of dollars, then they will give you the appropriate attention. Obviously, if Warren Buffett from Berkshire Hathaway calls up the Jones Day, or he's going to get, let's put it this way, I'll give you 120 billion reasons why they will give him attention.
We'll go to the front of the line.
Yeah. So there's a direct relationship really between how much money that you have and a level of attention and skill that you're gonna receive. My companies would really never work with a huge law firm. We always will with individual lawyers. The other thing that I found with larger firms, unfortunately, is that they are more inclined to take more risks ethically, which can get a little bit bouncy.
Yeah, I would say so.
They feel that they're insulated from the ethical rules, but because of the money that they have, okay, they get dinged for doing something unethical. Okay, well, we'll pay the sanction that we have. Or they're a little bit more of a cowboy attitude towards the ethical rules. Contrary, you asked about what the difference is between a larger firm or calling up myself, my office. When you call me up, you talk to me. It's very direct, and because of my network, I have the luxury of being able to spend time with the client, listen to their problems, get the backstory, because there's always a backstory to every potential client that calls up, and I can spend the time with them. When you get the backstory and we have the luxury of getting the backstory and spending the time with the client, it makes it more easy to solve their problem more effectively and efficiently than if you're just, spending 10 minutes and worried about the retainer. I don't take retainers. Like I do my work for clients on either a contingency basis, which means that if I don't achieve the result that the client wants, I don't get paid, or I work on a flat fee basis, which,
right.
I mean, with a contingency basis, you always have a happy client because they don't get what they want, they don't pay. Flat fee, they know how much they're going to pay, and they're not going to be billed a penny more. So there's a predictability element to the flat fee. You never have a client that's like a larger law firm or a law firm that takes retainers that call up and say, they get this like 3-4-page bill every month of all these different charges, and clients get a little bit peeved, especially when they're paying money and they're not getting the results, and they're getting these 3-page bills.
So you have a pretty broad practice. You do business acquisitions, debt settlement, consumer rights. What do you find most challenging about navigating multiple specialties?
The most challenging thing is the keeping up with obviously the changing regulations and rules and laws and that are endemic to various specialties. Certain specialties, the laws change a lot, like taxation. I can tell a client today one thing, and in 3 hours, it'll be different. It's a hyperbolic example, but taxation is an area of law that changes very, very rapidly. Estate planning also, they change the lifetime, the gift exemptions, the lifetime, the numbers change. So you tell a client, well, it's, I don't know, X amount of dollars that you can gift someone, and then they'll change it like next month or next year. So you have to be cognizant of that. And there are other areas of law that don't change, like contract law. Contract law pretty much stays pretty level. And even it's been around for a couple hundred years, it doesn't change. So you have from the sublime to the ridiculous. But I keep up very, very diligently with the areas of law that I practice, which is debtor-creditor rights, debt collection, which includes debt collection, debt settlement, business disputes and litigation. I keep up with procedural rules, evidentiary rules. I also do securities and taxation, which are extremely fluid and very complicated. But I constantly, every single day, research and keep up with the areas in law that I practice. So
Yeah, it sounds like you kind of have to with that many changes.
Yeah, I mean, it's the best practice is being that way. So it keeps you out of trouble. It keeps you effective, really, an ethical requirement. I forget what the rule number is, but the rules of professional conduct state that you shall represent your client diligently and competently and within the bounds of the law. So to be competent, you have to keep up with the law. And to keep up with the law, you have to research and you have to read and put in the work, which I do every single day. So that's a long answer to your question.
That's okay. No, this is perfect. This is,
I really was excited to kind of get to know you and for our audience to get to know you and kind of understand your overall outlook on how you approach cases and how you approach your business. So I appreciate your time and thank you all for tuning into The Fixer with experienced attorney and author John Tatoian. To connect with John, you can visit johntatoianlaw.com or you can give his firm a call at 860-490-4138. And of course, don't forget to like and subscribe to our channel here. We really appreciate you being here. John, it was great chatting with you and learning more about you, and I'm excited for the next episode.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.